All right. So one of the things I want to make sure that you understand is these strategies do exist. Everybody's situation is different. We at ELG Estate Planning may recommend options and strategies for you to consider, but one thing that we will never do is put these strategies ahead of the person's care. Quality of care is paramount. Everything that we do is to support the care, and if we can protect, preserve assets, we will do so, but never will we put our clients in a situation where the care will be jeopardized. That's really important for me to share with you. I personally, in our family, helped mom and dad with 14 years of long-term care. And I know that the most important thing for a family is that their loved one's care is appropriate and is not compromised. So I just want to share that with you. In order to do these strategies, we have to have the right estate planning documents. We have to have durable powers of attorney that have gifting authority for couples that also have the ability to do a separate property agreement. When we are working with clients who have very flimsy, weak, old powers of attorney, sometimes our hands are tied and we can't do the things that we would like to do to help the client. So make sure you've got really good durable powers of attorney. And what by that I mean, make sure an elder law attorney did them, because an estate planning attorney might say, oh, gifting authority, sure, we'll limit it to the annual exclusion amount of $17,000 per year. That doesn't work. I might need to recommend to the client that they give away $230,000, $17,000, and if the person's lost capacity, I can't do that strategy. All because the attorney who drafted the durable power of attorney did what is very common and traditional from estate planning and doesn't understand elder law, because they don't practice elder law and they don't practice Medicaid, whereas a Medicaid elder law estate planning attorney will make sure those durable powers of attorney have necessary authority in them to do any of these strategies that I've just talked about with you. Wills, I mentioned this before, should have that supplemental needs trust in it to protect assets and preserve government benefits and protect against estate recovery. One other thing about revocable living trusts, very common throughout the country. In Washington, not as common, though certainly a revocable living trust might be an appropriate planning platform. But when it comes to Medicaid planning, does not work at all. A house in a revocable living trust is no longer an exempt resource, it's exempt. A revocable living trust does not allow us to create that supplemental needs trust on death to protect the assets, to preserve eligibility of the Medicaid spouse, for example, and to protect against, estate recovery. So RLTs, revocable living trusts, simply are not a good idea in Washington for Medicaid planning.